(2018-242) State of Arkansas versus Eli Michael Weedman. Mr. Weedman, you're appearing for arraignment here today on a charge of being a possession of a firearm by a certain person, also referred to as felon in possession of a firearm. It's my understanding that you've made application to the Public Defender's Office. Is that correct? Is that correct, sir?
Yes, sir.
All right. Very good. You also have on the docket, on this court's docket, 2018 208. I believe you were arraigned on that charge on back on May 17th when you appeared before the court.
Yes, sir.
And the charges in that case are two Class D felonies and a misdemeanor, all drug-related charges. That case is already set on my docket for your next reappearance. Is June 21st. Okay. In addition, it appears that you have case 2018-221. I think you were arraigned before Judge Putman on the charges in that case. And so the court is if you made application to the Public Defender's Office in case 218-242, the court is going to go appoint the Public Defender's Office to represent you. If there is a mistake being made that you haven't applied in 2018-242, you need to get an application. Make sure you fill that out. But I'm going to go ahead and make the appointment. You obviously qualify for the representation. So the Public Defender's Office is being appointed in 2018-242. Court is going to direct that the defendant or request of the attorney of the defendant. How does the defendant plead on the charges of being a felon in possession of a firearm, a Class D felony?
Your Honor, he enters a plea of not guilty.
All right. This matter is set by scheduling order for July 12th as a reappearance date to discuss the status of the case. August 30th is set as a pretrial. October 18th is a plea deadline, and the week of October 22nd as a trial. His trial will be set down. And again, that will be on scheduling order. You may be excused at this time.
Thank you.
2018-240 State of Arkansas versus Christopher Jenkins. Mr. Jenkins, have you made any arrangements to be represented by an attorney at this point?
No, Your Honor, I have not.
Okay. Well, the court's going to quickly explain. You have the right to an attorney. That's a constitutional right guaranteed to you. What you do in order to secure an attorney is up to you. If you decide to go out and hire the attorney of your choice, the court doesn't even get involved in that process. That's a matter of private contract between you and the attorney you want to hire. If it is your belief or you just come to the conclusion that you cannot afford to hire an attorney, you're entitled to appointed counsel. The way you secure appointed counsel is you make application to the Public Defender's Office. You're being handed a copy of the application right there. As I say, they're available there at the jail. I think you've just been handed one to secure appointed counsel. You fill that out, sign it, and turn it in, and that'll get circulated to a judge who will review it and make the appointment. That's how you secure an attorney. At the present time, as I said, I think I already told you, you're charged with possession of controlled substance, Schedule 3, a Class D felony, possession of drug paraphernalia related to methamphetamine or cocaine, that's a D felony also. And then there's possession of controlled substance, Schedule 4 or 5, Class A misdemeanor, possession of drug paraphernalia, Class A misdemeanor, and driving on a suspended license. All of those are charges that have been lodged against you. On those charges, how do you now plead?
Not guilty, Your Honor.
Okay, your plea of not guilty is noted here on the record. Is it your intention to apply to the public defender's office or hire private counsel?
The public defender at this point in time, depending upon whether I still have a job or not, we'll see from there.
All right. I'm noting that you're applying. Your case is assigned to the Division 4 docket of this court. It is now set for trial the week of October 22nd. You're set for pretrial on August 30th, a plea deadline on October 18th, and a reappearance on July 12th. That'll be the next time you're ordered to appear in court, is July 12th. You may be excused at this time.
Thank you, Your Honor.
All right. (2018) 106, State of Arkansas versus Dwayne Burr. There's also case 2018-237. Today's date is a pretrial hearing in case 2018-106. Is there any pretrial motions to take up?
Your Honor, there are no pretrial issues to take up in case number 18106.
Okay. His next appearance in that case is scheduled for August 16th, which is the plea deadline. Moving now to 2018-137, which is for arraignment. Now, I got a 237, excuse me. Mr. Cooper, have you been employed or appointed to represent Mr. Burr
Your Honor,
in this case?
he is in the process of hiring me, and I feel comfortable announcing to the court that I represent him privately. I would enter a plea of not guilty to these charges.
Let's see. The charges are delivery of Schedule 2 controlled substance, Class B felony, second count of delivery, greater amount is Class Y felony, possession of drug paraphernalia, Class D felony, theft by receiving, Class A misdemeanor, all with an enhancement provision on it. I'm noting a plea of not guilty on those charges. The case is currently assigned to Division 3 docket of Judge Putnam.
Your Honor, I would move that 18-237 be transferred to Division 4 so that both of his cases will be on this court's docket.
All right. Court is going to transfer the case to Division 4. And we'll take it on our docket. I'm going to set it on our current scheduling order with one modification. That is, I'm going to set it for trial the week of October 22nd, and October 18th will be a plea deadline. I'm going to make the pretrial date August 16th, which corresponds to the plea deadline case in 2018-106. I'll keep that date, and then in in case 2018-237, Mr. Burr is ordered to reappear on July 12th. That'll be the order of the court.
Thank you, Your Honor.
All right. Are there any issues of bond?
Not at this time, Your Honor.
All right. All right, Mr. Burr, you may be excused. Court calls 2016-395, State of Arkansas versus Andrew Cunningham. Mr. Cunningham, you're appearing this date for arraignment on a charge on charges of that is on a petition to revoke your probation. The allegations contained in the petition to revoke, which was originally filed back May 25th of 2017. The petition contains allegations of absconding, failing to report, failure to pay fines and fees. Those are the allegations contained in the petition that I'm looking at. On those allegations, how do you now plead?
I plead guilty, sir.
Well, I'm going to enter a plea of not true on your behalf. You're not represented by an attorney at this time. You are entitled to be represented by an attorney.
Yes, sir.
And until you've had an opportunity to consult with an attorney, I'm not going to accept a plea of guilty.
Yes, sir.
Your arrest is relatively recent. Your case is for revocation will be on Judge Putman's docket, and I'm going to set it down for hearing on June 28th in front of Judge Putman. In the meantime, I'm going to advise you that you have the right to an attorney. That means you have the right to hire the attorney of your choice. And if you do that, the court's not going to be involved in that. However, if you can't afford to hire an attorney, the court's advising you still have a right to an attorney, and in that case, you'll need appointed counsel. Appointed counsel will come to you by you're making an application to the Public Defender's Office. Those applications are available there at the jail. I just saw the officer hand you a copy of the application. I'm going to recommend to you that you fill it out and turn it in to get counsel appointed for you.
Yes, sir.
So that's where you stand at this time. You may be excused. You need to fill out that application and get it turned in so that counsel can be appointed and start acting on your behalf as soon as possible. Your case is currently set for revocation on June 28th in front of Judge Putman.
Thank you, sir.
You may be excused. (2018-46) State of Arkansas versus Christopher George. This was set down as his pretrial date by scheduling order in front of this court. Are there any pretrial issues?
You know, there are no pretrial issues on the case that is on your docket, 18-46.
Well, the case is still scheduled for August 20th, the week of August 20th, with a plea deadline of August 16th, which is the next time he's ordered in to appear. All right.
Your Honor, there is also on the docket case number 16-291, which I believe is a Judge Putman case. Mr. Bailey represents Mr. George in that matter.
Is that a revocation?
Yes, Judge.
I think it has to be before Judge Putman. All right.
Your Honor, does it reflect that he has, he was not aware when he called our office if he has a a date to reappear on the revocation.
I can look that up. Here's the petition to revoke was filed in January of 2018, January 26th. The warrant was served, according to this, on March 22nd. Court appointed a counsel was, Public Defender's Office was appointed on April 11th. Motion discovery was filed, and I'm not seeing any date set on it. I don't see in the record available in Court Connect a setting. It doesn't even show he's been arraigned on the revocation petition.
I have.
You have not?
No, sir.
Gunner, he has applied to us on 291, and the court has, Judge Putnam has appointed us.
Oh, you have an appointment?
Yes, Judge.
Okay. Well, that appointment came after, when they made the initial arrest, it was on March 22nd, and they put it down for him to appear on that same date that he was arrested. But it doesn't appear that he ever appeared or got anything on that. So at this time, the court is going to advise him that the allegations contained in the petition, which was filed back on January 26th, are that on or about January 22nd, the defendant committed the offense of possession of a controlled substance with intent to deliver, possession of controlled substance, methamphetamine, possession of drug paraphernalia, possession of controlled substance, and careless and prohibited driving. All of that, as I say, is in 2016 291. And I guess those are the new charges that we've just we've got him on our scheduling order. So those are the first of the violated the law. Second, of possessing controlled substance. So that's a violation. Association with other persons engaged in criminal activity. That's another reason. And then unpaid fines, fees, and restitution that reflect the total amount of over $4,700. All of those are allegations contained in the petition. The court will, in 2016, 291, how does the defendant now plead?
Not true, Your Honor.
I'm noting his plea of not true, and I'm going to set him for appearance on June 28th in front of Judge Putnam for hearing on that matter.
For June when?
June 28th.
I have a date in Fulton County on June 28th.
Well, right now you're in Baxter County, and I'm not going to set any bond for your release at this point. So in all probability, you're going to be here on June 28th. But that matter is in front of Judge Putnam. So we'll.
Is there any way that we can resolve the issues that I have right now with your court today? Since I'm here on pre-trial, I'd like to. I haven't had a plea. I have not spoke with Mark Cooper. I don't know really what's going on.
Your Honor, Mr. George, with the revocations being filed in Judge Putnam's court, then there's Mr. Bailey's involved in that. I would not advise him to plead out on anything until we can try to do something concurrent on all your charges, Chris, including your revos.
Okay.
And I know nothing about your revos. There's no further action, Your Honor.
All right. Court is directing that he reappear on the revocation petition on June 28th.
Your Honor, I will tell Mr. George that once Mr. Bailey and I make a determination as to who is going to represent him on all these cases, or if it's both of us, that one or both of us will be down to see him next week.
All right.
Okay,
You may be excused.
thanks.
Two 2018-238, State of Arkansas versus Dustin Blair.
Your Honor, I'd like to enter my appearance for the defendant. We would waive formal reading of the information, enter a plea of not guilty. And we would like to be heard on the issue of bond, if we could, Your Honor.
I'm noting Mr. Friend as the attorney of record. The charges are aggravated assault on a family or household member, a Class D felony. On that charge, how does Mr. Blair plead?
He would enter a plea of not guilty, Your Honor.
That plea of not guilty is noted. This case is on this court's docket. I'll be setting it for trial the week of October 22nd. October 18th will be a pre-trial day. It will be a plea deadline date. August 30th will be set down as a pre-trial date, and he'll be ordered to reappear on July 12th.
If we could be heard on the issue of bond, Your Honor.
On the issue of bonds, court.
His current bond's at $100,000, Your Honor. Mr. Blair's requesting a reasonable bond. All his ties are from our local community. I believe he's always lived here, Your Honor. He's got 2 or 3 young children that need his attention. I believe he's got a place where he would bond out. We would just ask the court if we could get a reasonable bond today.
What says the state on the issue of bond?
Your Honor, this man's bond is presently set at $100,000. This gentleman threatened to kill 3 of his family members. He was in possession of a firearm. He actually, according to the affidavit, he pulled back a .25 auto handgun. I don't know what caused that, Your Honor, but that's still present. The state believes that a $100,000 bond is necessary in this case. The victims are fearful of this man. There is no other place for him to go than back to them. And Judge, for right now, we'd like that bond to sit right where it's at. I'd like an opportunity to talk to those victims face to face. But at this point, we have an adult son who's threatened his parents.
Your Honor, we just note that we don't feel Mr. Blair, excuse me, is a flight risk. We don't know where he would go. I believe he would attend court. We know that he couldn't bond out to the victim's home, but I believe he would have a different home that he could bond out to if the court would lower that bond, Your Honor.
Given the nature of the charges and the allegations that have been stated, the serious threat to the life of 3 other people, the court's going to leave the bond at $100,000, feeling that that is an appropriate bond in the circumstances. It will be conditioned on him having no contact with any of the victims, which apparently are his parents and a brother, and that'll be the order of the court. Bond will be left right there.
Dustin, I'll come over and see you here in a little bit, okay?
Yes, sir.
All right.
Thank you, Judge. If I may be excused.
You may be excused.